Okay, good afternoon, everyone, and thank you for joining us. I have the distinct pleasure of introducing our moderator and timekeeper, Kristen Conwell. Kristen is an alumni of the Neil Blackshear Fellowship Program sponsored by the NCBJ. Neil Blackshear was a bankruptcy judge who served in the Southern District of New York for over 20 years, who the NCBJ has named a scholarship program after. It is an effort to increase diversity and inclusion in the bankruptcy practice, and we are very delighted to have Ms. Conwell serve as our moderator today. Kristen is Chapter 7 panel trustee from the Eastern District of Missouri. Prior to that, she served as a trustee with a staff attorney as a staff attorney for the Chapter 13 trustee in the Southern District of Illinois. And previous to that, she served as an attorney in the law office of Tracy Brown, another Neil Blackshear scholar. Ms. Conwell is admitted to the practice of law in Missouri and Illinois, and she's a graduate of the University of Kentucky Law School, where she was a staff articles editor for the Kansas Journal of Law and Public Policy and president of the Black Law Students Association. Prior to becoming an attorney, she worked for more than 13 years in consumer banking and personal trust management. Another tidbit, she's the mother of a 9-year-old son. She is a diehard Jayhawks fan, was excited as heck last year when they won the NAACP championship, in NCAA championship, I should say. And she loves constitutional law, which makes today's headlines particularly interesting to her. So without further ado, Kristen, you have the floor.
Thank you, Judge Hopkins. It's such an honor to serve as a moderator, and even more so to introduce our esteemed panel. Everyone, you just heard from Judge Jeffrey P. Hopkins, who was appointed to the bankruptcy court in Cincinnati in April of 1996. Judge Hopkins graduated from Bowdoin College with degrees in government and legal studies and anthropology sociology in 1982, and earned his JD in 1985 from the Ohio State University Michael E. Moritz College of Law. Upon graduation, he clerked for the Honorable Alan E. Norris on the Sixth Circuit and later became an associate with the law firm now known as Squire, Patton, and Boggs, specializing in complex commercial litigation. In 1990, Judge Hopkins was appointed as an assistant U.S. attorney and rapidly advanced to become chief of the civil division. Judge Hopkins was elected president of the National Conference of Bankruptcy Judges in 2007. He served in several leadership roles, including chair of the NCBJ MBA Liaison Committee, where he founded the Blackshear Lecture Series and NCBJ Presidential Blackshear Fellowship Program in order to attract underrepresented minorities to bankruptcy law practice. Chief Justice John G. Roberts Jr. appointed Judge Hopkins to the Committee for the Judicial Branch and more recently to the Judicial Conference of the United States as the Bankruptcy Judge Observer. In 2010, Judge Hopkins received the William K. Thomas Distinguished Jurist Award from Ohio State. Currently, Judge Hopkins serves as board chair of the iconic Cincinnati Museum Center, president of the Law and Leadership Institute, co-convener of the Black CBA Roundtable, and board member of the National Underground Railroad Freedom Center. Judge Hopkins is married to Michelle. They are proud parents of one daughter who is the clerk for the Honorable Wendy C. Cross and one son attending Ohio State. You will also hear from Judge Brian Kinney. Judge Brian Kinney was sworn in on September 1st, 2011. Prior to his appointment, Judge Kinney was a principal in the Tyson's Corner office of the Miles and Stockbridge PC, a 200+ attorney firm with offices in Maryland, Virginia, and the District of Columbia. After becoming a member of the Virginia State Bar in 1983, he represented creditors, debtors, and bankruptcy trustees in the Eastern District of Virginia and elsewhere. Judge Kinney graduated in 1980 from Virginia Commonwealth University, magna cum laude, with a degree in political science. Judge Kinney graduated from the University of Virginia School of Law in 1983. A frequent lecturer on bankruptcy matters, Judge Kinney has been a presenter on continuing legal education panels for the American Bankruptcy Institute, the Virginia State Bar, and the Mid-Atlantic Institute on Bankruptcy and Reorganization. He has published articles in the ABI Bankruptcy Journal, as well as law news for the Virginia State Bankruptcy Bar Section. And last, but certainly not least, Judge Andrew Altenberger was appointed to the bench for the United States Bankruptcy Court for the District of New Jersey in Camden, New Jersey on May 19th, 2014. Prior to his appointment, Judge Altenberg served as law clerk to the Honorable Daniel J. Moore, United States Bankruptcy Judge for the District of New Jersey in Newark, New Jersey, as an associate for the firm of Davis, Reber Kinney, and Abramowitz in Cherry Hill, New Jersey, and finally, as the sole shareholder of Andrew B. Altenberger Jr., Esquire PC in Marlton, New Jersey. And I am advised by influential members of the NCBJ that Judge Altenberg was a member of the best bankruptcy baby judge class ever held. Before I turn things over to our panel, I want to let everyone know that if you have any questions during the presentation, please type them in the chat section that is located at the bottom of your screen, and we will try to make sure that they are addressed. So without further ado, I'm going to turn it over to Judge Altenberg.
Thank you, and great shout out to my class. I appreciate that. So I'm going to apologize first to all you folks. For one thing, I'm going to be looking down at my notes because last week I was asked to speak about my case at our State Bar Association annual bench bar conference. And I realized about halfway through my debate with Judge Gravel that the theory that I was following, I was calling it the wrong theory throughout my debate. So I want to make sure I get all my notes and answers and positions to you folks correct. So I suspect one of the reasons why I'm on this panel, not only was I selected by one of my baby judge colleagues, but I recently had a case called the case of In re Lars Alier, which is reported at 63 BR 677. And in that case, we were presented with the issue where a debtor filed a motion to sell their home free and clear of all liens and to seek a payoff of their Chapter 13 plan. From the time of the original confirmation until the sale of the property had appreciated $129,000, which here in New Jersey, due to COVID, for some reason, all prices and house valuations have been going up. So they took an opportunity to take advantage of this. Under the debtor's plan, the property vested in the debtor. Under the confirmation order, it was silent, so the plan ruled, and the plan only provided for the future submission of future income, no sale. That was it. Of course, the trustee objected because the debtor wasn't over median income, which a short payoff would require 100% plan if it was to be paid off early. And second, the trustee argued the appreciation no longer belonged to the debtor, and that's really what set off the issue here. I should say right away, there might be some confusion as to this. There was no modified plan proposed for an early payoff. So the issue of plan modification was not before me. The issue was, could this property be sold, and who does the appreciation go to? So it really became a question of vesting and how to harmonize sections 1306 and 1327. Now, as we all know, the relevant portion of 1306 provides that property of the estate in Chapter 13 cases includes all property specified under Section 541 and all property that the debtor acquires after the commencement of the case. However, Section 1327B provides that except as otherwise provided for in the plan or the order confirming the plan, the property vesting under subsection B upon confirmation vests the property of the estate in the debtor. Then there's 1327C that says that that property vested absent an order or a plan provision to the contrary, is free and clear of any claims of any creditor provided for under the plan. So the issue was, well, this debtor's selling their property. Can the property be sold? And the answer, yes, obvious, but who does the appreciation go to? And looking at the matter, there is no Third Circuit case directly on point. There are cases in the Third Circuit that directly deal with the issue. And what we found was that there really are basically 4 theories on this appreciation of an asset in this type of situation where someone seeks to sell property post confirmation and post vesting. And the first theory is the estate preservation theory, which my the judge that I succeeded to, Judge Wismer, entered a very thorough opinion. And it basically rests on the idea that the term vesting under 1327 means a debtor's rights and interest in the property become fixed as of the date of the confirmation of the plan and are affected when the provision of the debtor's Chapter 13 plan are satisfied. In other words, the definition of a vest merely gave an immediate fixed right of present or future enjoyment. The problem with this approach, if you look through the cases, is that it puts all its weights on I knew I was going to say weights on Section 1306 and ignores 1327 in its entirety, especially the language that under 1327C is free and clear of all liens. Interestingly enough, this theory is criticized in large part because it makes 1327 as mere surplusage. But as you all may recall, recently in the Supreme Court case of Chicago, City of Chicago versus Fulton, the Supreme Court has warned us against the use of or against surplusage, and especially where it would make superfluous another part of the statute. So that's the issue with the state theory. It really relies on 1306 and property stays, but the critics are saying it ignores 1327, which can't be done. The next theory is the theory of the estate termination. And that theory basically says all property becomes property of the estate upon the confirmation, and basically the bankruptcy estate ends. Well, this obviously puts all the weight on 1327 and ignores 1306. Proponents say it's necessary because it allows a debtor to a choice at confirmation of what property remains property estate and what property vests in the debtor. It preserves and gives credence to 1327C, especially the part about what's free and clear of any claim of creditors. But again, this also ignores the issue of irrelevant statutes. So it ignores 1306 in its entirety. So I was not comfortable in especially with the guidance that we have from the Supreme Court, ignoring that statute. The next was the estate transformation approach, which says all property becomes property of the debtor except for property that's essential to the performance of the plan, which sounds almost correct. It seems to make sense. And then again, the debtor is free to spend his or her wages and use his or her assets as long as he fulfills his plan obligation. It's really, there is a contract between the debtor and the trustee and the creditors. I think it's a valid approach, but again, it has its problems. It reads non-existent language and into a statute distinguishing between property necessary for consummation of the plan and that is which is not. And again, it's not clear what property belongs in the plan, what property doesn't, and property that may have been essential to the plan at the beginning may no longer be essential because of stuff that had happened post confirmation. So again, it leaves it up in the air. So the approach that I thought best harmonizes the 1306 and 1327 and the idea. I'm a big believer in a plan is a contract, you know, and parties are bound by a plan unless it's perpetrated by fraud. And I think Espinoza, and here we have Zostek, says the same thing. You're bound by a plan. This is it. You had your opportunity. He says, I thought the best approach would be the estate replenishment approach. And this approach says all property becomes property of the debtor but then the estate refills regardless of whether the property is necessary to carry out the plan. Again, this harmonizes 1306 with the idea of post-petition property coming in and being able to be used for the plan. It recognizes 1306 and acknowledges the vesting provision. And it also recognizes that what I think is important here for chapter 13 cases 1327C, where property that vests is free and clear. Again, it's the contract. Debtor has contracted to make these payments. If I was to allow the debtor or the trustee here to claim appreciation when it wasn't provided for in a plan, when the plan was clear that the property vested, I was giving a power to the trustee that doesn't exist under the plan, in that they're allowed to attach a property that has vested free and clear of any claim or interest of the creditors under the plan. So I felt that that was a problematic approach.
Judge Altenberg, 1329B also said, or 1327 says, unless otherwise stated, the debt vests back into the estate, and some plans do that. We have chapter 13 trustees who sort of insist on that in our jurisdiction. How's that change the dynamic?
Well, I think that if, in my case, if the property had not vested, I'd have a different conclusion, because it remains property of the estate. And I have to follow 1306, which says that property becomes property of the state post the petition and post confirmation, and it didn't vest, so it remains property of the state. There's no question about it.
One of our audience members, Oliver Gardner, has raised a question that when I was reading your case, it just came to mind because I have a similar case, as you know. And did anyone after your ruling in this case move for modification?
So I was trying to stay away from that part, but okay. No, nobody did. And it's funny because I have, after I was going to discuss this, there is a list of cautions. No, nobody moved to modify the plan. And I'm going to jump right into it. Just one point I wanted to make. I also have difficulty with the concept of appreciation as a separate asset than that of the real property. So that played part of the role in what I was doing here. I can't see how you can separate. You can't pledge, mortgage, or hypothecate or liquidate appreciation. It's all part of the same asset. So appreciation in and of itself is not income. Sure, if you sell the property, it becomes income, but appreciation itself is not income, which might fall in 1322. But as you pointed out, Judge Hopkins, this was not a plan a case where a modified plan was there, and nobody moved to modify the plan. And this is what I want to caution against, and this is what the trustee in last week's seminar with me, we were going back and forth on. It may be a different ballpark if you move to modify a trustee or a holder of an unsecured claim on the 1329A moves to modify the plan when a debtor seeks to sell property, because when you do that, you have to look at the elements, and you still have to confirm under 1329B, you have to comply with section 1322A, 1322B, 1323C, and 1325A. And 1325A means that you have to propose a plan in good faith, and an argument can be made is a debtor acting in bad faith when they have an opportunity to pay creditors and still reap a reward with any appreciation above and beyond the creditors. There might be an argument made there, but more importantly is 1325A5, which says the value as of the effective date of a modified plan is what counts. So in this scenario, if there was a motion to modify the plan or a modified plan was filed, we'd be looking at the appreciated value because it's the effective date of that plan that's being confirmed. And of course, all the judges know under any scenario, when there's a plan being confirmed, there's the best interest of the creditors test. So as I cautioned folks last week, my matter was a matter of where on a sale of property and whether the appreciation vested in the debtor. It could be a completely different picture if somebody seeks to modify the plan. Now, I would also add to this caveat, because I was thinking about this morning. 1322A, or excuse me, B says or excuse me, A says future earnings or income. So I'm not sure appreciation alone is enough to modify a plan. I think it's appreciation and sale proceeds would have to be there. But just because a piece of property appreciated, I don't know if that's grounds enough to modify a plan, because a modified plan only includes future earnings or income and not sale of assets. And there might be an argument made that just because a house appreciated, it doesn't mean the plan has to be modified.
I can totally
Judge-
not believe the trustee didn't move to modify after your ruling. I mean, I would have at least tested the waters. I'm sorry, Kristen, go ahead.
That's okay. Judge Altenberg, are Chapter 13 trustees objecting to plans that vest assets in the debtor at confirmation? That's a question we've gotten from the.
Well, that's an interesting, so it seems like the proper resolution, and I said this in my opinion. First of all, I did say I didn't want to go down the rabbit hole of talking about the modification issue because it wasn't before me. But the other issue is certainly you can reserve rights. Future income or future appreciation is part of the plan. I have seen some orders that have been modified since my argument or since my decision, where they require a vest. If there's something appreciates during the life of the plan, then that goes to the benefit of the creditors of the state.
We have another question. Was there a homestead exemption available to the debtor in this case?
Well, New Jersey doesn't have a complete homestead exemption, so most people take the 522 exemption. So it was available. This was above and beyond. It was $129,000. Debtor had already claimed the exemption originally. So, and that's another issue that was brought up last week, is what if they change their exemption? You know, exemption is valued at the time of the petition, unfortunately.
Yeah, it's a snapshot rule. It's pretty universal across circuits.
Right.
We have another question. How does your theory of appreciation in a plan modification square with cases that hold that there is only one effective date of the plan for the purposes of 1325A4?
Well, I'll answer this the best way that I can. That issue is not before me. I haven't thought it out. I'm a practical reader of the code, and I don't see how, I mean, this might be surplusage. Or superfluous. I don't see where it says effective date in the statute says as of the original plan. It says as of the date of the plan. I don't see it in the statute itself. But
And the modified plan becomes the plan under the code. So courts read that differently. I read it, that, the new modified plan is the plan, and other courts say, there's only one plan. It's a unitary thing, and it goes all the way through. I don't get it.
I don't get that approach. Not to say someone can't convince me otherwise, but I'm reading what the code itself says.
Okay, as a follow-up question, assume the debtors don't immediately pay the secured claim in full and continue to pay and continue to perform under the plan to pay mortgage arrears, tax sales certificates, sewer liens. A year later, the debtor defaults. Is the secured creditor left without collateral since the house has been sold? What's a secured creditor to do?
Your creditor gets paid.
At all times.
They're gone. They don't care.
I would think if the house is sold, the secured creditor would have been paid. Title company in New Jersey won't close unless there's an agreement not to release the lien. So,
Right.
don't know how to answer that question. I apologize. All right, well, that's my 15 minutes of fame. I really shot through it all. I appreciate the questions and the comments from the panel. It's a slippery slope right now. Again, I have to make the distinction. The modified plan wasn't in front of me. I still believe in the power of vesting in plan confirmation, but you still have to satisfy the elements upon a modified plan. So, which can be brought by pretty much anyone. So with that, I guess I will turn it over. I think it's you, Judge Kinney, correct?
Yes, good morning, everybody, and thank you, Andy. Thank you, Kristen and Jeff, for the kind introductions. My issue is what happens when the case is converted to Chapter 7. Debtor is in a 13, let's say for a couple of years, and then maybe she loses her job and she can't continue to make the payments. But during those 2 years, as we all know, across the country in many cities and localities, we've had quite an increase in market value, just market appreciation. So you get 2 years of market appreciation, and then the case converts to Chapter 7. Who's entitled to that equity when the trustee goes to sell the property? So it's really a trustee, Chapter 7 trustee versus the debtor's issue. And I wrote an opinion in 2015 called In Re Goins, Goins, which is found at 539 Bankruptcy Reporter 510. And to make a long story short, as Jeff Hopkins alluded to earlier, I held in favor of the snapshot rule, which is to say, it seemed to me that the property was always property of the estate, number one. And number two, I think what drove me to the decision that the trustee won and the trustee got the equity in the property was Section 541A6, which says that property of the estate includes, quote, proceeds, product, offspring, rents, or profits from property of the estate. So if the property, the real property in the house, is property of the estate, it seemed to me that it was impossible to separate the proceeds of the sale, including the market appreciation, from the property itself. And so to me, 541A6 determined the issue, and the trustee was entitled to the appreciation. Following up on a question that was asked with Judge Altenberg, I think in my case, the debtors were entitled to some form of exemption. We, in Virginia, we don't have a complete exemption. We have a limited exemption of $25,000 per spouse in the property. It could be $50,000 together, but as I recall, they took their exemption, but there were still proceeds available. But In Re Goins really based on the idea that the appreciation was never severable or separate from the property and was property of the estate under 541A6, I held in favor of the trustee in Goins. Now, fast forward to 2022, very recently, the 10th Circuit issued a case called Barrera, B-A-R-R-E-R-A, at 22 F 4th 1217. And it was a 10th Circuit, also a converted case. The basic facts are pretty much the same as in Goins, the fact pattern of appreciation during the 13 conversion to Chapter 7 and who's entitled to the proceeds. And I suppose to my surprise, the 10th Circuit held in exactly the opposite way of my decision in Goins. And the 10th Circuit says the debtor wins, the debtor's entitled to the proceeds. Now, why is that? Reading the Barrera opinion, it seemed the 10th Circuit, 2 points about the 10th Circuit's opinion. Number one, the 10th Circuit said that, and I'm quoting here, the sales proceeds, a property interest distinct from the physical house from which they were derived, do not enter the converted Chapter 7 estate. So they're making a distinction between the proceeds and the property itself. And in fact, in footnote 1, they said, and I'll just quote here briefly, we need not decide whether appreciation in a house still owned by debtors at the time of conversion is property of the debtors or the estate. That is not the case before us. We are dealing with proceeds, and they italicized the word proceeds. We are dealing with proceeds from the sale of the house, not the house itself. So the 10th Circuit made a real distinction between the proceeds of the sale and the real property itself. That was kind of the pitch that was made by the debtors in my case in Goins, and I just didn't see how you could separate the proceeds from the property itself. And as I say, to me, it seemed that Section 541A6 answered the proceeds question. But the 10th Circuit also had a second point that is worthy of, certainly worthy of consideration. And that is Section 1327B, where they said the automatic vesting provision of Section 1327B supports our conclusion that the proceeds from the sale of the debtor's house are not included in the Chapter 7 estate. They went on to describe the vesting provision. Confirmation of the Chapter 13 plan vests all property of the estate in the debtor. Now, that's an interesting and an important point, and I don't know that it was really the focus of the arguments in my case in Goins, but it also seems to me that I'm not sure the divesting provision answers our question, because I don't think anybody disputes that when a case is converted to Chapter 7, that the property is property of the bankruptcy estate. And putting aside the issue of the appreciation in the property for the moment, let's just say the property didn't appreciate, but it still had equity in it over and above an exemption. I don't think anybody would dispute that the Chapter 7 trustee would have the ability to sell that property with court approval and paying the exemptions to the debtor, paying the liens and so forth. So if that's the case, it seems to me arguable that reliance on the vesting provision of Section 1327B really proves too much. I mean, if that were the case, if the vesting provision means what the 10th Circuit seems to say it means, then when a case is converted, what does the Chapter 7 trustee have to sell? The answer is nothing, because the property vested in the debtor, and now it's the debtor's property, and it's no longer property of the estate. I don't know any bankruptcy judges who would sign off on that as a proposition. So it seems to me that relying on the vesting provision for the proposition that this increase in market equity during the course of the 13 now vests in the debtor, it proves too much, essentially, because it would take the property itself out of the bankruptcy estate, and I don't think that that's what's required by virtue of the vesting provision. I will also say, and it's just a brief footnote, that in our confirmation orders, in all our Chapter 13 cases in the Eastern District of Virginia, the confirmation order says, notwithstanding vesting of the property in the debtor, the Chapter 13 debtor is still required to come to court for approval of a loan modification or a sale of the property. So we just want to make it clear, and I don't think that that's controversial either in bankruptcy courts, but we want to make it clear that notwithstanding vesting under Section 1327, that effectively we're still treating it as property of the estate. So at the risk of repeating myself, I'm not sure that I see that the vesting provision of Section 1327, well, it proves too much. So
Barrera takes it way farther than that. I mean, they basically say that the debtor is free to go. All he has to do, or she has to do, is make good on the payments under the contract with creditors. And you can borrow, you can do, we don't do that here either. I don't know.
do you mean during the 13 or even after conversion, Jeff?
No, in the 13 itself.
In the 13, right?
Yeah, when it vests, in other words, and back into the debtor.
Isn't it really a matter of practicality? A title company is not going to close without a bankruptcy court order, sale of the property or anything like that. So it's a necessary evil to get that approval, isn't it?
You can take
Right,
Barrera, wave it around at the closing and say, hey, I can do this.
But really, I just don't see how we can make this distinction between the proceeds of the property and the property, particularly in light of Section 541A6. But, you know, far be it for me to be too critical of the 10th Circuit. And, we'll see where this goes. Perhaps it'll create a split in the circuit someday, and we'll get an answer.
Yeah. Judge Altenberg quotes me in his decision, which, that doesn't very often happen. So thank you, Judge. But he says several courts have suggested that these provisions are difficult to reconcile and even maybe impossible to reconcile. When you start weaving through 1327B and 1327C and 348F and 1 and 2, it gets really confusing.
It seems to me that the vesting provision is really not a title issue so much as it is who controls the property, from here on out, right? Who's going to pay the homeowner's dues, who, the post-petition, the homeowner association dues and that sort of thing. It's kind of a signpost that tells us, okay, now the debtor's really in charge of the property from here on out. But I don't think it really answers the question of what happens when the case is converted and, clearly the trustee in a converted case gets to sell the property. I don't think Kristen would disagree with that
I
proposition.
certainly would not.
Right.
We have a question. Given they say pliability in valuations, what is done to verify what the true appreciation is?
Well, that's a great question because that's a real evidentiary issue. In my case, in the Goins case, the trustee was really willing to accept the debtor's scheduled value. So we didn't have to go back and value the property, 2 years ago, 3 years ago. And they stipulated to a value because I think, as I recall, the trustee had it under contract. And so it was really kind of a question of where the proceeds are going. So, it's sort of been market tested. We'll accept the schedule valuation for 2 years ago, and now we have a contract, and that's the market value of the property. So, in my case, it wasn't a difficult sort of evidentiary question, but it's a good question because that's not always the case. Right.
There's a series of cases out of the Ninth Circuit. The Lynch case, it's a Ninth Circuit BAP case, 2007. It talks about when valuation occurs in the 13, it sort of carries over into the Chapter 7 because creditors have had an opportunity, trustees had an opportunity to object, and it becomes binding essentially under 1327. Comes the deal. If it's right.
And that's a tough issue. I mean, let's say in the 13 you've stripped off a completely unsecured second mortgage, but now there's equity in the property and the case has been converted to a 7, right? I don't know what the answer to that is.
We've had a couple questions about the impact of 348 F1, both A and B, and how that plays into the analysis. I have it here if you don't. It's when a case is under 13, converted to another chapter, A provides that property of the estate in the converted case shall consist of property of the estate as of the date of the filing of the petition that remains in the possession or is under the control of the debtor on the date of conversion.
Yeah, as of the date is, to my way of thinking, the as of the date issue is answered by nobody disputes that the house was property of the estate when the debtors filed, and that the debtors continued to own the property as of the date of conversion, right? So the big difference between the 10th Circuit and my thinking in Goins is 541A6 says property of the estate plus proceeds. So I don't know that 348 limits that in any way. And that's kind of my view on it.
Mm-hmm. And we have another question. Does the Schwab v. Riley decision that concluded exempt interests, not the property itself, preserve appreciation for the estate under 1306?
I hadn't thought about it in those terms, really. I mean, that's an interesting question. Jeff or Andy, any thoughts on that? I'll put you on the spot.
I would, it's an interesting question, but I don't, so for New Jersey, your exemption is limited regardless to the federal exemptions. I mean, there are state exemptions, but nobody really ever takes them. So I don't know if it would come into play. I guess there'd be a different answer if you can completely exempt under a homestead exemption. I think there'd be an answer that it probably does protect it. If you can exempt the entire homestead under state law, I would think that'd be protected.
Yeah, I think that's right. There are some, the homestead exemption is what the homestead exemption, you claim it and it's there, it's preserved. And I think anything in terms of appreciation above that exemption amount is what we're really at, what's really at dispute when these cases come before the courts.
Yeah, I think that's exactly right. I mean, in Virginia, we have, as I say, a dollar amount exemption. In states like Florida or Texas, where you're, unlimited amount of homestead exemption, then I don't think the trustee is going to try to sell that property, right? It's exempt.
Yeah.
Or, the other exception in Virginia is we have tenants by the entirety property. And if there are no joint claims in the case, then the trustee is not going to be able to sell that property because she can only pay joint claims out of the proceeds of T/E property. So tenants by the entirety property is really in Virginia an unlimited exemption, with the footnote being joint claims need to be paid.
Well, that's taking us back to law school, Judge Kenny. I faced that when I sat in Florida. T/E, what the heck is that? I had to go back to my property book.
Oh, it's important for us. It's still.
Oh, I know, it's big, huge. Florida as well.
Right.
Judge
Okay.
Hopkins, could you please repeat the Ninth Circuit BAP citation that you just
Oh,
gave?
shoot, Lynch, I don't have the site. I can maybe
Were they-
give it to you. Let me do this for you. If you shepherdize a couple of cases, it's a Ninth Circuit BAP decision from 2007, but it cites to Hyman. It's another Ninth Circuit case, but that's the actual Ninth Circuit. It's 967 F. 2nd 1316. And the Reed case, 940 F. 2nd 1317 from 1991. Basically, those two cases hold that, the increase in the net value of any asset owned at the petition date and yours to the benefit of the debtor, absent bad, yours to the benefit of the estate, unlike the Barrera case that came out of 10th Circuit. So the Ninth Circuit's already on board, but again, those are older cases. And I don't know what, oh, someone's got it. Great. Somebody put it up there.
Right. Let me just address one question very, very briefly, because we have a question from Mr. Brandt, who is a lawyer who practices in front of me on our Chapter 13 docket regularly. And we enjoy having him in court. And he says, Judge Kenny, can you address the issue of appreciation and house sale for those who do not convert to 13 and stay in the 13? I will address Mr. Brandt's question by saying Judge Altenberg has already covered that issue, and I'm content to rely on his erudite discussion of it.
No advisory opinions.
Thank you.
Okay, since I'm batting cleanup, I'm going to start with a quote from Satchel Paige, the great African-American baseball player, played in Negro leagues and then probably pitched for the Cleveland Indians when he was 40 years old and still did pretty well. He said, "Don't look back, something could be gaining on you." And I quote this because you're likely to come across one of these cases, as Judge Altenberg alluded and Judge Kenny alluded earlier. We're in a red hot economic market when it comes to real estate. And with these values increasing as they are, it creates issues for us to have to deal with. So another great baseball player, I'm going to quote Yogi Berra, said, if you come across one of these cases, if you come across a fork in the road, take it. So yeah, I don't know. You're going to have to deal with it. So, as I said, you're dealing with a host of statutes, a plethora of statutes that come together when these issues arise. And just as a practice note, I wanted to identify for you when these things can come up, if I can find my note to that effect. So it can come up in a declaratory action. It did in the Castleman case, which is one of the prominent cases which deals with this, which holds that the increase in the net value nearest to the Chapter 7 estate goes in the direction of Goins and Judge Kenny's decision. It's an adversary proceeding. 7001, 2, and 9 apply in those situations, but Castleman holds that it's waivable. But I checked my circuit to make certain that that's the case. So it can come up there where the trustee says, you know, I'm going to declare that these appreciated values above the exemption amount are property of the estate. Motions to modify, and that's frankly how I got introduced to it. It was my case, the Scholl case, that was decided back in 2019, I should say. It's 605 BR 163. I don't recommend you read it. I recommend that you read the Barbosa case that came out of the First Circuit. Judge Joan Feeney was affirmed in that case, and it really deals with this issue quite nicely in a motion to modify. The other case on the other side of that is the Baker case by Judge Brown out in Colorado, and she does a wonderful job of going through the analysis, and she applies 348, she applies 1327, and gets a different result than what Barbosa and I did in Scholl. It can come up in turnover, 542, where the trustee, as in the Barrera case, sought turnover of the appreciated amount from the sale of the home. Can come up in a circumstance of an abandonment in a Chapter 7, where the debtor says, you know, we abandoned this property. It has no value, intrinsic value to the estate, so it should be abandoned. Obviously, the Chapter 7 trustee may have a different view of that. And it can come up in a motion to sell, as in Judge Altenberg's case under 363, where the debtor moved to sell and to pay off his plan early, and it drew an objection from the trustee. So the two schools of thought you've heard much about, Barrera, the Cofer case out of Idaho, that the Cofer case comes from Paul, Idaho. So it shows you how hot the real estate market is. There, 4 months into the case, the house had appreciated about $30,000 in Paul, Idaho, with a whopping population of 1,600 individuals or souls who live in that community. But the Chapter 7 trustee there sought to sell the property after a conversion, and the court had held that it inured to the value of the debtor unless there was bad faith under 348. The second school, as Judge Kenny has outlined, the Castleman Barbosa case. My case, Scholl, let me just give you the facts of it. Probably the reason I've asked to speak on this panel, but I did speak to a judges group of this on this question a while ago. Last year, Bill Brown, as you know, who is a bankruptcy judge who's retired now, writes treatises in his spare time, asked that I join a panel, and we were talking to judges. So those of you who are practitioners, you're inside the tent on this one, because there is a huge debate going on amongst our colleagues on how this all plays out, because it's all over the map, and we still haven't had. I don't know that we've had a dominant strain of case law yet. I think there is a split in the circuits. You've got the Ninth Circuit, as I said, the Hyman case and the Reed case, and now we have a more recent case with Barrera going the opposite direction from the 10th Circuit. So we shall see how this all unfolds in terms of whether Judge Kenny is right on his interpretation with 506. I'm sorry, what is it? Help me out. 541.
41A6, yeah.
Yeah, whether that will prevail and proceeds from the estate will be the dominant strain, or whether we go through this analysis that Judge Brown in the Baker case, and I commend Baker to you because it's really well written. She does a wonderful job of pulling all of the statutes together and expressing her view on it. Let me see if I can find the site for you. for the Baker case because it is, I really recommend it. 620 BR 655. It's a 2020 decision by Judge Elizabeth Brown out of the District of Colorado, where she goes through a pretty awesome analysis of how she gets there. And let me just point to where she ends up. This was a competing motion to modify in a 13. The debtor sought to modify to be able to retain the appreciated value. Basically, the debtor had sold the property, same fact pattern as Judge Goins, converted to Chapter 7, had a huge appreciation. They had $140,000 of appreciated value that was sitting in a bank account at one point. By the time that the issue was raised, they had spent $40,000 and they still had $100,000. The debtor sought to reconvert to Chapter 13 when the Chapter 7 trustee came after those funds, which the court denied. But then the court essentially held that the debtor is entitled to keep those appreciated value. She relied on four rationales. She said the estate termination approach was the better interpretation of 1327 among the three schools of thought that Judge Altenberg has talked about. Further, she found that the rules of statutory construction under 1327 was a more specific statute compared to provisions of 1306. Third, she held that in a nod to Chapter 11, she reasoned that 1141 parallels Section 1327B, and that when property vests in a Chapter 11 context, it is no longer property of the estate. And lastly, she referenced 349B3, which uses the term revest. By way of example, she noted that the dismissal of a case revests property of estate into the hands of the entity in which such property was vested immediately before commencement of the case. And that usually refers to the debtor, but in some cases, it may refer to another entity, like in the case of a fraudulent conveyance. When that unravels, the property returns to the transferee. So I commend the Baker case to you, but my case, Scholl, arose in the context of a motion to modify. There, the debtors owned several rental properties, and they had an insurance policy for replacement, which paid them rather than any creditor. And during the course of the bankruptcy, both rental properties, first one went by and was destroyed. The second rental property is one where the issue arose. The debtors moved for distribution. They wanted to receive all of the proceeds from the property being destroyed and the insurance policy. The Chapter 13 trustee, however, objected and moved to modify under 1329. And at some point in time, they came together and they actually had an agreement. And I go through an analysis. I basically say, insurance policy, and this is kind of key to the holding. An insurance policy is property of the estate. That's pretty universal among all the circuits that have ever dealt with that question, especially in yours to the estate's benefit when it pays the debtor. So it's property of the estate, no question there. But then who gets the appreciated value? So we're now in 1329B land, where Judge Altenberg wanted to avoid, but I had it squarely before me. So how do you do this? I mean, you have to reapply 1325A. You got good faith, and you've got the best interest of creditors test. Now there is a debate among colleagues and among courts on whether you reapply a new best interest of creditors test or you refer back to the old one. Judge Brown and Baker says, no, there's only one, and you do it at the petition date or confirmation, and that's the end of it. Well, I don't know. I mean, you look at the legislative history. I know we're not supposed to do that in this plain meaning environment, but you look at the legislative history, and the history in the statute basically says, yeah, there is a new test that has to be applied. And, if you do that, when you get, $100,000 worth of insurance proceeds and you propose to pay creditors only a portion of that and keep the majority for yourself, I don't know that you meet the best interest test anymore. And certainly you don't meet the good faith test, at least not in the way I held it in that case. So that's kind of how I was introduced to this. And I'm going to leave time, Kristen, for questions that may arise.
We have a lot of questions and they're mostly about the conversion. We have a question that asks, what about a scenario where a debtor is in a Chapter 13 to protect equity in real estate and 2 years later, the market tanks and no longer has equity? Say convert to Chapter 7 at that time. Do we apply the value at the time of conversion?
I'm not sure what's being asked there. The value for purposes of selling the property. I mean, it's going to sell for what it's worth. And if there's no equity in it, our trustees, for a long time, were doing a lot of short sales. I was approving short sales as long as there was a quote meaningful benefit to the bankruptcy estate in the form of a carve out, and what that meaningful benefit was is, anybody's guess. But I certainly wouldn't approve it if it's just a trustee's fee and nothing more. And nobody proposed that, in fairness. But I don't see, for what other purpose would you value the property, say, as of the petition date when it had equity? What
Right.
good would that do anybody?
Yeah, I mean, you can't get anywhere with that as a 7 trustee, really.
You'd abandon the property, right?
Right.
Exactly. Judge Kenny, we have another question for you. It says, can you address the issue of appreciation in a house sale for those who do not convert and stay in Chapter 13?
Well, that was Mr. Brandt's question, and no, I'm not going to address that any
All right.
further than Judge Altenberg has educated us all on the issue.
Looks like that was asked several times by
Yeah, I know,
several
it was repeated in the
people.
comments.
Yeah,
They really want
Um,
an answer to this question.
yeah. Litigate it, you guys. How should we address the property that has not appreciated, but the equity has increased by the debtor's mortgage payments?
Oh, paid out cases are easy. They're excluded. I mean, you can't go after that.
Yeah, I agree with that.
I think
That's a
there's
question.
case law about that all over the
Yeah,
place
yeah,
too,
yeah.
saying
It's
exactly. what
actually
you're
in the
saying.
history of 348 as well.
Mhm.
How about this is, I think probably you're going to say the same answer, but how about it when the appreciation is just a result of inflation? How would you prove that? Any thoughts?
Some courts talk about this, and I think Judge Brown and Baker talks about it. What if the scenario unfolds where, you're in a rising housing market and, somebody just moves to modify because now the house is worth more? Should you be required to pay more I don't know that I agree with that, but that's what some courts are troubled by, frankly.
I go back to the issue of it's a contract and the only thing is appreciation, then I would have a hard time finding the need to modify a plan just because the house appreciated.
Yeah.
We have a comment and you may want to comment on the comment. However, a debtor is free to modify and then the trustee is on defense. Then the debtor must establish that the plan, which I read as the modified plan, satisfies 1325A4. Plus, the debtor, in seeking to modify, has the advantage of the administrative exemption, which adds to the state federal exemption with the hypothetical liquidation costs, trustee costs, fees, etc. What is sauce for the goose should be sauce for the gander.
I object. That's a compound question.
Well, all right.
I'm not sure I understood the question,
Maybe we can
frankly.
answer it.
Yeah, I think some got lost in translation on that one, but
In this example, the debtor is proposing a modified plan, a 1329 plan. And
yes,
what, wants to use the value as of the petition date? Or, no. This is a decrease in property in this example, right?
I think they're asking about an increase.
Uh.
But maybe it goes back to the point of that earlier question where they did ask about a decrease. And if the 7 trustee couldn't get it in that scenario, then maybe they can get it in a scenario where there is increase. Anyway, these situations will play out in a courthouse coming to you soon. I think that brings us to all of the questions that have been asked, and we are now at an hour. So that brings us to the conclusion of today's program. I want to thank the judges for an awesome discussion, as well as the sponsors, ABI and NCBJ, for the Behind the Bench series. Thank you to everyone who attended today's seminar, and we really hope that you will continue to join us for future presentations.
Okay, well, thank you for the opportunity to participate. Enjoyed it.
Thanks, everyone. Great panel.